Okay. Добрий день.
Good morning, Dmytro. Can you see and hear us? Yes, I can see and hear you. Good morning, we can start.
Вітаємо вас на другому
Welcome
етапі
to stage 2
до Вищої кваліфікаційної
of the selection for HQCJ. This is the interview stage.
з вами проводить комісія.
So today your interview will be conducted by all of the members of our commission. Let me introduce our commissioners: Robert Brugheisen, me, Ivan Mishchenko, Steven Markman, Sergei Varlanov, Yevhen Mezentsev, and Ted Zazhechny. The rapporteurs for your interview are going to be me and my colleague, Steven Markman.
Пане Дмитро, якщо з технічних
Dmytro, if for any technical reasons the broadcast will be interrupted, we're talking about power outage, air raid alert, or loss of internet connection, we will stop the interview and it will be resumed. And that is something that we will have to coordinate with you. Yes, thank you, clear.
прохання відповідати коротко.
We are kindly asking you to be very precise and succinct in your answers, because I hope all of the commissioners would like to ask you a question. And at the same time, the commissioner asking you their question has the right to limit you in the duration of your answer. That's clear. Before we start the interview itself,
Представити себе.
you are given the floor for self-introduction. You will be able to tell us more about your motivation, about your ideas, about things that you consider to be important with regards to continuation of the judiciary reform and the HQCJ in particular. So you are welcome. So I would like to welcome all of the honorable members of the Commission and the people watching this broadcast online. Glory to Ukraine and glory to the armed forces of Ukraine. My name is Dmytro Bezdolia. I was born in 1979. I'm the citizen of Ukraine. I have a degree in law. I have the overall experience of more than 20 years working in the field of law, and half of that is me working as a judge. I've completed the qualification assessment, and over the period of my professional activities, I've never been charged with any disciplinary action. I'm currently working as a judge of the Commercial Court of the Odessa Regional Court, and I'm also part of the Association of the Development of Judicial Self-Government of Ukraine, Association of the Judges of Commercial Courts of Ukraine, and Association of Investigative Judges of Ukraine. So I started my career in the Chancellery. I was assistant judge. I was head of a law firm. I was a trainer at the National School of Judges, and since 2012, I've been a judge. I believe that my professional career is connected with the judiciary. I hold an active stance in my life. That's why I decided to participate in this competition, because I understand that the activities of HQCJ will lay the foundations as to the functioning of the Ukrainian judiciary for decades to come. I do have extensive experience of cooperation with my colleagues, with other associations of lawyers, international organizations, bodies of judicial self-government, and other branches of the government. I was a member of the working group by the Committee of the Verkhovna Rada pertaining to the issues of judiciary, and a committee by the High Council of Justice. In view of the fact that the majority of judicial cases are settled at local and appellate courts, and they have the highest workload of judges, and this has an impact on the quality of justice, I do believe that the activities of these courts should be the priority of the HQCJ that will be selected. People should feel the change, not just in the work of the Supreme Court of Ukraine and HCJ, but also in the work of courts. In my opinion, it will be the best result of the judiciary reform. That's why I believe that HQCJ should have a significant representation of judges of trial courts. And the priority tasks for HQCJ should be the following. First, participation in the creation of PIC. Second, initiation of the shortening of the procedure for the selection of trial court judges. Number three, selection of the procedures on the update of selection procedures, including amendments to the legislation, should the lawmakers agree to that. Number four, completion of qualification assessment. Then completion selection for the positions of judges of Kyiv City Administrative Court, completion of the selection initiated by the previous HQCJ. Number six, running competitions for transferring of judges to the courts of the same level and completing selection for judges of trial and appellate courts. So that's basically everything I wanted to tell you in my introduction. I will be happy to hear your questions. Thank you, Dmytro. So you're the head of the Association of Judicial Self-Government Development in Ukraine. So this NGO, together with others, 2 years ago, it appears to me, wrote a letter to the President of Ukraine urging to veto the draft law which foresaw the creation of the Ethics Council. In that letter or petition to the President, there are the following quotations. With this letter, we'd like to draw your attention to the fact that this draft law is a threat to sovereignty of Ukraine as far as the procedure of creation of judiciary bodies is concerned. It negates the principles existing in Ukraine, creating threat for further formulation of the judiciary bodies, because the influence of foreigners on Ukrainian judiciary system may be adopted and used in the future. So if to summarize this, it means that the participation of international experts in the selection of people for the judiciary bodies is a violation of Ukrainian sovereignty and in general is unacceptable. In view of the fact that you are currently participating in the selection where half of the commissioners are international experts, how can you comment on this position of yours? Can I answer your question now? Yes, thank you for the question. To be honest, I was expecting it. Well, first of all, let me draw the attention of the honorable commissioners that I'm participating in the selection for HQCJ, and that letter had to do with the activities of the Ethics Council, that is selecting members for HQCJ, for HCJ. Yes, indeed. I'm the president of this association. I'm the head of the board, and the board is a collegial body, and it's made up of 21 judges. And every petition like that should be voted for during board meetings. And as the head of the board, I have to sign any documents like that. So I see this petition in front of me. It was signed on behalf of 4 associations: Association of the Development of Self-Government, Association of Commercial Courts, Association of Female Judges, and Association of Retired Judges. I have to tell you that I indeed supported the position expressed in this letter, and let me explain why. Well, it's quite a revolutionary step. I mean, the involvement of the international experts in the issues of formation of judiciary bodies. In particular, if we look at the fact that I'm a judge myself. I believe that international experts who are members of selection commission over the time of their work on the selection commission have had the time to be convinced that Ukrainian experts are also professionals who are able to select members for HQCJ in a professional way. it should also be mentioned that this petition, this letter, was sent during the stage when it was a draft law. When the law was signed by the President of Ukraine as a law-abiding citizen, after announcement of the competition, since I'm not a person who is indifferent to the judiciary, because I've dedicated many years of my life to working within the judiciary, I have made this decision for myself to participate in this election, to get my personal first-hand experience of participating in competitions like this. It should be additionally noted that as a citizen of Ukraine, I really value the support that Ukraine is currently getting from international partners. We see this support in how the armed forces of Ukraine are able to resist the enemy. That is why if the international experts who are members of the selection commission will help us create the HQCJ that is as strong as the armed forces of Ukraine are, we will be indeed very grateful to those international experts for this great, strong composition of HQCJ. Yes, I understand your position, Dmytro. So has your position really changed since the time that you've sent that letter? Your personal position. I mean the following. I'm not doubting your position as the head of the board of the association, or your position as a professional. You can be either for or against the involvement of international experts. This is your choice. But on the one hand, you sign a letter where you're criticizing the participation of international experts, and on the other hand, you're participating in the selection where these international experts not only are involved, but also have the decisive vote. So has your position changed since the moment of signing that letter? So how can we interpret this? I believe that at this historical stage in the history of Ukraine, this involvement of international experts is justified. So you have changed your position. Well, taking into account the events currently taking place and the scope of international support that we are receiving from the EU and the US, yes, my position has been adjusted, let's say. Thank you. Thank you for this answer. Since you are the head of the association, you're quite a public figure and you often give comment. On social media, we found an interview with you where you are asked questions about the judiciary reform, and you're answering as follows. It appears to me that everybody wants to control the courts in any way possible. Some people do it via reforms, limitation of judicial immunity, decrease of salaries for judges, creation of HQCJ, HCJ, creation of PIC, etc., etc. With regards to this position of yours, do you still believe that the reform is a way to control, including this reform? Can I answer? Yes, you're welcome.
Thank you for the question. So, actually, you have not voiced the exact question, but let me mention that this happened in January 2017. I think that the members of the selection commission, judges, do remember the period of time, 2015, 2016, when each high-profile and not fully high-profile case gathered crowds of people in front of the court premises. They brought some loudspeakers, tired rubber tires with them, and they were trying to somehow exert pressure on judges. And the police didn't take any effective measures. You remember that was the period of time when there were attacks against judges. Judges could be poured on with some liquid, and judge was not protected at all.
Заяви певних публічних осіб, коли, наприклад, не подобалось рішення суду певного.
And if somebody disliked the decision of some court, a certain official could make a public statement that we don't need any guard for judges, we need to remove guards for judges. We also remember the period of time when every politician could state in any case that there should be judicial reform, but judicial reform actually consists in dismissal of all judges. And you remember the judges who were appointed in 2012 actually had this label. They were called the judges of Yanukovych, though they were not. And this evaluative judgment, well, existed then. And this was because of the circumstances. And how we differentiate between the right reform and the wrong reform? The reform which aims to exercise control over courts and judges, as you have mentioned, and the reform that would aim to actually develop the judiciary in the right direction. Yes, thank you for the question.
Судова реформа – це, по-перше, це має під собою мати покращення.
So every reform should be based on some strivings for improvement.
Я б зазначив, що судова реформа
And I would indicate that the judicial reform
для того, щоб кожна особа,
also aims at
чи задіяна в судовій
every person involved in the judicial reform to be able to express his or her statement, point of view. And then these ideas could be gathered and the best of the best could be chosen. I definitely agree that Ukraine is in need of the judicial reform, but it should be a civilized judicial reform. I think that now we have probably
перейшли в якийсь цивілізований рух, у нас напрацьовується
crossed this line, and finally we have this civilized judicial reform. Draft laws are being developed. We have an open dialogue with lawmakers. So finally we are there at this stage. And I think that now the judicial reform has started moving in the right direction already. And judges are finally heard. Their problems are heard. Because you realize that judges are professionals who are really concerned about their business, dedicated to their business. And they see the problems and challenges. Thank you for the answer, and let me give the floor to my co-rapporteur, Stephen Markman. Stephen, please, the floor is yours.
Thank you, Judge Mashenko. And thank you, Judge Bezdolia, as well, for your participation in this process. I've read your motivations several times, and I think in many respects it's very thoughtful, and we appreciate what you've written. You've probably prepared for my question as well, and I don't expect that I'll surprise you with this question. It has to do with your family relationships, but it's not the first question I want to ask you. I want to ask you something before I ask that question. As I think you're probably aware, during our interviews and prior to our interviews, there have been many commission inquiries into the relationships between families and friends and candidates in terms of finances and other kinds of things. And we've had many questions and inquiries concerning the nature of relationships between candidates and business associates or people who've recommended them or political associates. So there's been quite a bit of questioning in that kind of realm. And I will ask you in just a moment if you will respond to the nature of your family relationships with the Communist Party. But as I say, I'd like to ask you something before that. And my question is this, Judge Bezdolia. Can you see how some Ukrainians, even though you might disagree with them, can you see how some Ukrainians might find your answers to this question to be relevant in terms of their sense of trust and confidence in the judicial selection process. In other words, looking at the Communist Party in light of its outlawing by Ukraine several years ago, in light of its history in Ukraine, in light of the present situation in Ukraine, in light of some of the tragedies that this party has brought upon Ukraine, not to mention other parts of the world. Can you at least understand why there might be some in Ukraine, even though you don't agree with them, who would be concerned about the nature of this relationship? What would you say to such persons, Judge?
Thank you for the question. It's really true that I knew that I'm going to be asked this question, and I've got the answer to it. Well, first of all, I really agree with your question in which there was already some answer, but let me focus on it as a judge. The requirements of the law on the judiciary and status of judges show that I actually need, first of all, to prove my political neutrality. And there was even a decision of the European Court of Human Rights on this matter. But I realized that the society also needs some answers and wants to hear my answer to this question. So let me state that I am politically neutral. And in this specific case, my wife is meant. And our marriage was launched in 2019, but the events you're asking about are related to 2010. I was not a witness of those events, and that's why I can provide the explanation only from somebody's words of what I know. So as far as I know, in 2010, my wife, my current wife, was elected the head of the local center of the Communist Party. In 2015, and this is the information I saw in some materials. So in 2015, there was a court decision that this party was actually banned. Under the law on political parties, this court decision constitutes the grounds for termination of membership or for dissolution of the party and, of course, its local center. So if we're guided by the requirements of the law, back in 2015, any engagement, any relation to this party was stopped. Of course, I've had a talk with my wife on that point. I got the explanations. She said that the events of 2010, when she was elected the head of that local center, and some political activity within this political party was not actually conducted by her. And she said that actually it was in 2010 that this activity was actually stopped. It even never started, as she says. But I must say that now my wife does not deal with any political activity. She is a good and loving wife, and she deals with tourist services provision, and all her activity lies in sending tourists to the EU and to the West for Ukrainians to see how people live there. So we hope that Ukraine in the nearest future will be able to join the European family. That's my answer.
However, can I repeat my question again? I'm hesitant to raise these things with you. I know how difficult they are, but the issue is difficult for many other Ukrainians too. Do you understand how some Ukrainians might feel more strongly about this than others might?
Well, let's have a look at this situation. First of all, the fact that my wife belonged to the Communist Party has stopped. I mean, currently she's not a member of the Communist Party. If we take me, I generally had nothing to do with that party.
Я, звісно, зі своєї
Can I just clarify some of the
я
facts,
кажу,
Judge?
не
just so-
сприймаю цю політичну, не сприймаю цю
I
політичну партію.
do not
І
perceive this political
я
party
повністю підтримую
in
закони,
any
які
way. And I fully
прийняті
support the law that was passed in 2015 on the banning of the communist regime and condemnation of this communist regime. So that's the only thing I can tell.
There are other family members who have a similar connection. Is that not correct?
Ну, колись мали, так.
Well, they used to.
Шлюби зі
That's
мною
try. That's true.
Could you describe what those are, please, or were? Just so the record is made as clear as we can make it at this point.
А наскільки я знаю, то
But
ще
as far as I know, the father of my wife was also related to the Communist Party.
Did your wife's connection continue until 2015 and its banning, or did it end at some earlier point?
розумієте, я як суддя можу бачити, ну, давати такі свідчення,
You know,
бути більш публічно.
I cannot, I'm a judge and I can give this testimony only on the basis of documents. As I saw it from the examination of some specific materials, well, I saw that there was reference to the decision and the decision was passed in 2015. But I didn't see any activity on her part, but I cannot give you a detailed answer because I don't have the materials.
Okay.
Розумієте, ну,
Is there anything else you'd like to say about that issue?
Well, you know, the specificity of my work is that I can tell you only what I'm sure of.
але в 2015 році ця
But in
історія
2015, that was definitely the end of the story because I saw the court decision.
тобто 7 років тому.
So it was 7 years
4
ago.
роки до мого шлюбу.
And this was 4 years before I married this lady.
Okay. Well, thank you for your answer, and for the time being, that's all I have to say. Thank you. Thank you very much.
Колеги, передаю вам слово.
Colleagues, let me give the floor to you.
Тед,
Ted,
чи є запитання, чи
are there any questions?
бажає?
Yes, thank you, Mr. Chairman.
Будь ласка.
Judge Bezdolia, I was looking very carefully and thoroughly, as we all do, at your motivation letter. And we have, of course, put 10 questions, very relevant questions, we believe, to all of the candidates and to you as well. You in paragraph 8, you spoke about mapping the future of the judiciary in Ukraine. And you said this, at least in the English translation of it. In the future, the judiciary should be a balanced and independent system of bodies that functions and implements the principle of the rule of law in all spheres of public life. Now, are you suggesting that that is not the case now? When you say this is your wish for the future of the judiciary, what is the situation now?
Ви знаєте, мені з цього приводу
Well, you know, thank you for the question.
згадується
I can recall
записки федераліста Гамільтона.
Hamilton's work, Federalist notes, that the judiciary doesn't have any access to the sword and to the treasury, and that's why it requires a lot of attention and a lot of protection.
Ви знаєте, що у нас на
You know that now, for 3 years, we haven't had the HQCJ functioning,
початку року
and
щойно запрацювала Вища рада.
the High Council of Justice has just started functioning. We've got the reforms going on, and there are a lot of courts that are in the temporarily occupied territories, so it means they cannot be fully functioning. We have a lot of other problems, and for quite a long period, the HQCJ has not been functioning. That's why a lot of judges have not been appointed. A lot of judges have not undergone qualification assessment, and a lot of judges whose 5-year term of office has expired, and they have been waiting for many years for this assessment for them to be able to keep working. So we cannot say that our current system is a well-balanced one. That's what I meant. And as far as independence is concerned, we have the High Council of Justice. When the High Council of Justice still operated, a lot of judges addressed it. According to the law, judges have to address the High Council of Justice in case of some pressure exerted on them, and the only mechanism the High Council of Justice has to use concerning such messages given by judges was addressing some authorized competent bodies or the General Prosecutor's Office. But that was the end to that. There were no legal mechanisms for really defending the judge and his or her interests. At least I haven't heard about any real mechanisms that would lead to real consequences. And also we are facing some issues with the judicial reform, let's say. Not a single body of the judiciary has the right of the legislative initiative. And these are the problems that need to be settled, so I hope that in the nearest future we will have the system well balanced and we will establish some constructive cooperation and efficient cooperation with other branches of the authority. That's my answer. Thank you.
Just on your answer, I don't quite understand what you're suggesting. Are you suggesting that judges or judicial associations should have some involvement in initiating new laws?
Yes, that's what I suggest. There is even the opinion on that point of the Consultative Council of European Judges, number 23, about the role of judicial associations. And this opinion of the Consultative Council says directly that association of judges should be active in such issues. And whenever a certain legislative act is adopted, the associations shall be entitled and shall have actually the mission to advocate the independence, to inform about some problematic issues, and to give their opinions. And by the way, in the Supreme Council, in the Verkhovna Rada of Ukraine, we have a committee on legal policy, and whenever they are dealing with some draft law, they can send it to us. They can send some requests to us, asking us to give an opinion of the association concerning this or that law. Sometimes we see that there is an important law and there are some gaps in it, and we prepare the opinion on our own and send it to the committee asking to take it into account. That's how we act now. Besides that, you know that according to the law on the judicial status of judges, the mandate, the competence to give opinions on the judiciary belongs to the High Council of Justice, according to the law.
Yes, I understood you to say that judges are seeking and associations are seeking to initiate new laws as opposed to responding or commenting on laws passed by the parliament. Did you misspeak there, or do you mean that judges should initiate new laws?
I meant to comment and, well, sometimes to initiate, but within the working procedure, because, you know, we all keep communicating with each other. We have subjects of legislative initiative, like MPs, committees. the committee has some task forces. And all task forces, well, for example, I'm a member of a task force dealing with the funding of the judiciary. It considers different issues related to provision of courts and the judiciary, and also develops some laws, and we give our suggestions concerning these norms. And whenever the document is developed, the subject of legislative initiative, like one or several MPs, put it to the consideration of the Verkhovna Rada by registration of the draft law. So life of this draft law starts, and it goes through the procedure from being a draft law to the law, in case there is political will for that.
All right, thank you for your answers. Let me move now a little bit more directly to the areas in your motivation letter where you recommend, by my count, some 7 particular requirements and changes that need to be made, in your opinion, to the procedures and the process of the HQCJ. It is, I think, commonly regarded that certain commentators have expressed the opinion that courts like the Supreme Court of Ukraine, together with the High Anti-Corruption Court, represented a process applied by the High Qualification Commission based on its regulations and its procedures and its process that led to some very improved results. Do you agree with that opinion?
As compared to what?
Well, as compared to all the problems that you have identified here prior to those 2 courts being appointed.
Well, the procedure for the selection of judges for the Supreme Court was new and transparent, and the selection was very professional. I do agree, we've not seen any procedures like that, before we had the competition for the Supreme Court judges.
All right, so in other words, the work of the prior HQCJ, as you understand it, respecting those 2 courts, was in keeping with high standards of judicial vetting and review.
Well, I've been a judge since 2012, a judge of the trial court. I don't think there's been that meticulous attention to the selection procedures as we've seen with the selection for the Supreme Court. I remember the selection for the Supreme Court taking place in 2017. I remember the exams and the evaluation and the testing. Well, but I cannot tell you in detail how it used to take place in the past. But probably the selection for the Supreme Court, because it was transparent, everybody could follow the selection.
All right, thank you. I'm going to pass the matter over to my colleague, Mr. Mezentsev.
Thank you, Justice. Пане Дмитре, моє прізвище
Dmytro, my last name is Mezentsev,
з'ясувати у вас такі
and I have this question for you.
це із ваших документів сьогодні.
So we've discovered it in your documents, and we've discussed it today that you are the head of the Association of the Development of Judicial Self-Government. So I would like to ask you about the specific measures that you're implementing as the head of this association. So you mentioned that you are drafting some petitions, perhaps suggesting some amendments to draft laws. you don't need to enumerate your obligations or mandate under the internal regulations, but please tell us what you were able to accomplish since the moment that you've become the president of this association. For instance, a specific draft law has been passed, or some of your proposals were taken into account and the state policy was changed as a result of that, in particular when we talk about the judiciary. What can you be proud of? It's quite a complicated question, and I will probably need some time to think before I can start answering, but let me try. There are several directions in our work. You know that our association is an NGO. We don't have any actual power. Yes, I do realize that. I've been in the system for up to 20 years, yes. So many members of our associations are part of different working groups. Some of the working groups deal with cooperation with the lawmakers, so they develop amendments to procedural codes. They deal with the funding of the judiciary. They look into demands of the judiciary. They also dealt with the development of the law 6311, which has to do with remuneration of the court staff. That's quite a sore point. And the association is paying most of its attention to this issue, to keeping the staff of courts. Yes, many people do pay attention to that. Yeah, I understand that. We also run public activities. What I mean by public activities, we organize roundtable discussions, different judicial forums. The most recent forum was dedicated to IDPs and refugees. So that was about the protection of individuals under martial law. The other forum had to do with Pravo Justice Project and also the activities of economic agents under martial law. So that's something that I can remember. Yes, that's clear. That's clear. That's quite enough. Let's not take too much of the time for answering this question. So the name of your NGO is quite powerful. So you want to develop judicial self-government. And judicial self-government is about the work of the Congress of Judges, the Council of Judges of Ukraine, as the executive body of the Congress of Judges. Could you please tell me, why don't you want to work on the Council of Judges? Why don't you want to become a delegate of the Congress of Judges and express your opinions over there? So you could take some active steps towards the reform that you are committed to, because you are the president of this association, right? Can I answer now? Yes, yes, of course. The Council of Judges has representation. Some of our members are on the Council of Judges. I'm asking about you specifically. You are passionate about the judicial reform and judicial self-government development, so why don't participate in the Council of Judges? Maybe you can become a delegate to the Congress of Judges. Well, but we have the acting Council of Judges. The composition has been selected. I've been selected to the Council of Judges twice. I know how it's done. You apply and you ask actually your staff, and they can delegate you, and you can try and become a delegate. You can become a delegate to the Congress of Judges or the Council of Judges. No, I have not tried to be selected as a member. Let's go back to the issues of criticism of the reforms. Of course, with regards to reforms taking place, and in particular, if we're talking about the scope of the judiciary reform, which has been around for quite some time, many people are discussing this reform. Some consider this as a way to influence. Others believe that this is necessary for improvement of the judiciary and its work. And the truth lies somewhere in between, as it always happens. Because you must agree with me that any government body, including a judiciary body, cannot keep to itself, cannot follow its own rules independently of the circumstances around, of what is happening in the country. Could you please tell us which of the elements of the judiciary reform do you consider to be the most relevant and maybe even requiring additional intensification? There are many aspects like that. Could you please give us just one example? That would be enough. Taking into account the time that we've already spent on the judiciary reform, the number of issues has amassed already. The first thing I can tell you is that we have two Supreme Courts. Well, we have one Supreme Court, but we needed to have this issue solved for quite some time. The judiciary reform is the completion of the selection of people for High Council of Justice and HQCJ. As far as HCJ is concerned, I believe that the majority has already been selected. The quorum has been selected. The service of disciplinary inspectors, that's also quite relevant. The territorial borders of our regions have also been changed. The e-courts issues, that's also important. Yes, quite enough. That's quite enough. Another question that I have. So you've mentioned that as of 2016, 2017, judges were unprotected and they suffered from being attacked by activists or unscrupulous politicians. At present, do you believe that the level of protection that exists in the judiciary, including the judicial guard, is sufficient? And if it's not sufficient enough protection of judges, what are your proposals to improve on this aspect? In comparison to the years that you've mentioned, the level of ensuring the security for judges has become better. It's a positive that we have the Judicial Security Service. The other thing is that we don't have enough funds for that, but that's a totally different thing. What I also believe is that we need to have the mandate for the High Council of Justice with regards to responding, so that the High Council of Justice doesn't only have the right to address, but also can hold to account people who don't respond in a duly manner, who don't take some necessary action. Thank you. That's all on my side. Good morning, Dmytro. My name is Serhiy Varlanov. My question is as follows. In your motivational letter, you state that to enhance the level of trust in the judiciary by the people of Ukraine, the HQCJ needs to ensure that the position of judges is occupied only by people who meet the high criteria of professional competence. So how would you assess the existing procedure of qualification assessment for judges? Should it be changed? And if yes, what are those changes that you are suggesting? Thank you for the question. Well, practically what I've mentioned in my motivational letter is something that everybody can agree with. I do believe that the personal and professional qualities of a judge should meet the highest standards. As far as your specific question is concerned, on the website of HQCJ, we can find the rules and procedures for the selection and assessment. They were all approved back in 2018 with some amendments introduced in 2019, but it's been 3 years since this time. That's why I believe that the new HQCJ needs to find some common denominator as to whether we need to update the existing procedures. I think that too many candidates during these interviews have mentioned that the first thing that should be changed is the simplification of the procedures by conducting special training, by decreasing the number of specializations, and by postponing it until later stages in the competition. In addition to specialization, if we are talking about selection of judges for trial courts, we need to think during training, we need to think about trainings, and we also need to pay attention to primary documents so that the judge who's been appointed has an idea how a tax declaration looks like, how tax documents look like. So we should pay more attention to the training of judges. Yes, we should pay attention to what the judge should do in their workplace. So they will get, for instance, a claim during the first day on the job. So in my motivational letter, I claimed that for some time when I didn't have the mandate, I was developing trainings for the National School of Judges. I was a trainer there, and my personal opinion as a practitioner is that a judge, in principle, must learn the practice of the Supreme Court of Ukraine, the documents of the Supreme Court of Ukraine. These things can be done by the judge themselves. Of course, we can draw attention to the students, but if it's not an assistant judge who's been working in the court for quite some time, I believe that this question of processing of documents and understanding of the structure of documents, of the things that the judge should pay attention to while reviewing them, I believe that this is something that could be used during training. Also, I mentioned the optimization of the procedure for the collection of documents. We could switch to e-documents in general. And over the time that we didn't have an HQCJ, there has emerged a need to analyze the practice of High Council of Justice with the review of their opinions when they disagreed with the recommendation for the appointments of specific judges. And also, I would draw attention to the procedures on the assessment. Maybe we should look about the mandate of the members of the HQCJ. If we look at the scoring for professional competence, ethics, and integrity, 300 points go to other indicators. What is meant by other indicators? And how are the scores being put? That is the question that I've asked myself. And several years ago, there's been a dispute between candidate judges and judges with respect to transfer, when we didn't really know how many vacancies in the courts should be transferred for incumbent judges and for candidate judges. And you remember there was the decision of the Grand Chamber, and I believe that we need to study this issue and find a common denominator as to how we should distribute the vacancies between incumbent judges and candidate judges. Thank you. Thank you, Dmytro. I don't have any more questions.
I have one final question, Judge Bezdolia. I indicated at the beginning I was impressed by your motivation, and that's so. It's the only motivation that I recall reading in this competition that set forth what's perhaps the most critical and indispensable aspect of genuine judicial reform, and that's a respect for the separation of powers. I can't recall any other motivation that's invoked that term. Could you please summarize in your own words why you think that's an important principle for the Ukrainian judiciary and for the Ukrainian government generally?
Принцип розподілу влади
The principle of the distribution of powers between the branches of government. Did I understand you correctly?
Так, правильно.
Yes.
Yes.
це ми принцип розподілу влади це вже декілька століть.
Yes, well, this principle has been around for centuries so that we have balance between the different branches of government so that the rights of the citizens can be protected, so that we have the rule of law.
Вона виконує функцію
The judiciary is performing the function of arbitrator between the executive government and the citizens, and the lawmakers adopt those laws under which the country operates. The only critical thing that I see is the funding of the judiciary. If you're interested in that, then I can dwell upon that in more detail. So the lawmakers are those who decide the scope of funding, and in recent years, the judiciary
на межі
has been on the verge of functional capacities if we are talking about the funding. So we lack even basic paper internet connection. So these are the practical things that need to be solved.
Well, I hope you will consider explaining and defending this principle to judicial colleagues and others over time, because at least in the American experience, it's an extraordinarily important aspect of our continuing debate over the apportionment of powers between the legislative and the executive and the judicial branches, and how the judiciary needs to limit its decision-making to avoid interfering with the other branches, and how the other branches need to avoid interfering with the independence of the judicial branch. So I thank you for your reference to that
у нас
concept.
в судовій у нас просто в судовій владі існує практика.
In our judiciary, we have this practice of discretion of their responsibilities and the power. And from the practice of the Grand Chamber of the Supreme Court of Ukraine, it is seen that we understand where the limit of interference is. So we can see how we can regulate these or that issues. Thank you for this very interesting question.
Thank you, Judge.
Well, my questions were around the same subject, and I was wondering, listening to you and what you say, whether you feel that the self-governing of the judicial system and judiciary in Ukraine has been successful up to today. Because you are in a body that strives, I believe, for the development of self-government. And when I look at the self-government of the judiciary in Ukraine, there's only one thing that I see, is that donors and sponsors and foreigners and tests show that the judiciary is not up to standard. And as a result of that is is that, for instance, we have this commission with foreigners who interfere in your self-government. And the reason for that is that up to date, apparently it didn't work. What did work, I believe, is that judges looked well after themselves in respect of remuneration. But you may be critical whether the last 10 years, when you were a judge as well, the self-government really resulted in an independent judiciary that was trusted by the people in the society. So I'm not sure whether I agree with my colleague on this table, who comes from another part of the world than I do, whether this is something that we should keep as it is, or there should be some changes. What's your view about that?
Дивіться, я почув від вас дуже важливу тезу з приводу того,
I've heard this very important statement from you that the key thing is trust.
це дійсно так.
Yes, that's indeed so. The judiciary reform depends on a number of factors.
Перший, напевно, фактор – це
The first one being professional competency of the people who are running this reform. The second factor is the availability of resources to have this reform. And the third factor, one of the most important ones, that is the political will.
наразі у нас судова реформа
Currently, the judiciary reform is taking place, and the participation of the international experts
кваліфікаційної комісії або Вища рада.
is aimed for the HQCJ or HCJ
Вона посилить.
to be reinforced so that the trust of people in these bodies and institutions is enhanced. And we as judges, I'm a judge myself, I do realize this.
Тривалий час, в принципі, намагалися
For a very long time, we tried to deal with this ourselves, but the issues of the restoration of trust,
в широкому сенсі.
in a more general sense, we were not successful in achieving that. That's why I hope that you will be able to find candidates amongst us who will be trusted by the people. It has to be trust on the part of Ukrainians, but also these members of HQCJ should enjoy the respect and authority amongst judges, because we should not forget that both HQCJ and HCJ are bodies of judicial self-government, where half of the composition, I mean the HQCJ here, is made up of by the judges, and they have to be the best representatives of the judiciary.
Крім того, наприклад, цей конкурс, який ми
Plus, the current competition is being broadcast on YouTube, so the procedure is transparent, and everybody who is interested
будує Вищу кваліфікаційну комісію, може
to watch, or all the other candidates can have a look at the interviews, what kind of questions are being asked. They are sometimes difficult, they are not always pleasant, but we still need to talk these things out so there is an understanding about the vision
буде, якщо певні
that this body will potentially have should specific people be selected. In addition to the transparency of the procedure, we should also remember that we need to follow the law and the standards of conduct, not only during your work hours, but also outside of your workplace. It's also very important. As far as restoration of trust is concerned,
довіра до державних інституцій,
trust in government authorities cannot be limited to courts or to high qualifications commission of judges. It has to be the entire system of government authorities working in a way that people have this trust and that they see the results of their work. The law enforcement system should also be effective. There should be the principle of punishment. inevitable punishment. And of course, we need to get this methodological and technical support from our international partners that will help us in improvement of our skills and vision. Because, as you know, Ukraine is a candidate state to join the EU, and we wholeheartedly want to join this union. Thank you for this question.
Thank you. My last question is, let's say, again, follow-up question. Can you please explain why you are someone who is someone who can make sure that change will happen, and why you are not someone who are someone of the past, who were part of the system where no change took place? And because the changes that are taking place, of course, also with the foreign experts on the table, they are designed to make sure that in the future it will all be better. And that is related, of course, to the people who will be elected in the position in the HQCJ and in the HCJ. And we must be sure that those are people who believe in change, are able to affect change. Why are you someone? Are you someone who believes in change, and are you someone who can affect change?
I can give you an affirmative answer that I believe in myself. If I didn't believe in my ability to effect change, then probably I would not have been here at this moment. As far as being capable of effecting change, I do believe that I have the necessary experience. I will not be reiterating that. And in addition, as it's been mentioned, I'm head of the board of a professional association of judges, so I enjoy trust on the part of the judges. They share my vision of the necessary changes, and I can honestly tell you that at this stage we have no other choice than to complete the change already happening and to change our country, to change our judiciary. Because we've already lost a lot of time, we are experiencing difficult circumstances because of the war, and it's our obligation to give our people the kind of courts and the kind of judiciary that would improve their standards of living so that they know that they have the defense of their rights and freedoms as the citizens of Ukraine.
Thank you. Mr. Chairman.
Thank you. Any more questions?
Чи є в когось ще запитання?
Пане Дмитре, з матеріалів національної
Dmytro, from the documents provided by NACP, we have the information that your family, since November 2020, according to the right of joint property, has an object of incomplete construction in Odessa, with the area of 66 square meters at Shevchenko Prospect. So, according to the data that we have from outside sources and on the official website of this residential complex, it is stated there that the construction has been completed and the facilities have been commissioned. So the question is, has your family registered the right of ownership to this property, and what is its value at present? Thank you for the question. Let me tell you that I have answered this question in writing. I have provided you with the agreement. If you may, please do explain this to the public. I have to be brief as far as I understand. Yes, the agreement was concluded on November the 20th, 2020 for payment in installments. Yes, indeed, this apartment has been commissioned, but I have the agreement of sale and purchase of property rights. I make payments according to a specific schedule. I have not yet made all the payments because I still have time and I still have a year to complete the payments. Well, this is not what I've asked you. So, do you already have the rights of ownership registered? Why have you not registered ownership? No, I don't have the ownership rights as yet because I haven't yet made all the payments. So you will get the documents after you've made all the payments, right? You only have property rights at the moment, right? Yes, it's only property rights. I need to buy ownership rights out. Yes, I understand your answer now. That's all on my side. Are there any other questions?
Пане Дмитро, на завершення
So, Dmytro,
нашої співбесіди комісія
in conclusion of your interview, the Commission gives you the right to summarize everything, to express your impressions. Should there be anything that you forgot to mention, or should you like to focus our attention on some things, you are given this opportunity for concluding statements. Yes, thank you. So let me summarize.
Україна зараз перебуває на дуже
Ukraine is currently experiencing a really difficult historical stage in its history. We have the outside front, where we are at war with Russia, and we have our internal front, and that is us fighting corruption and conducting the reforms, including the judiciary reform. And one of the stages in this judiciary reform is the creation of HQCJ, the selection of members for HQCJ. And as I've already mentioned, HQCJ should enjoy the trust from the public and should enjoy the trust from the judges. We should not forget about that.
я вважаю самої вищої кваліфікаційної
It's important not just to select members for HQCJ, but it's important to have the vision for its operation. It's important to understand what the HQCJ will do.
як і українські мої колеги, так і
I believe that both my Ukrainian colleagues and the international experts
зможете знайти
will be able to select worthy candidates amongst us who will be able to enjoy this trust of Ukrainians. Thank you for accepting this challenge, and I wish you the best of luck in your work. Thank you.
на цьому співбесіда завершена.
So this is the end of your interview. Good luck to you. Goodbye. Thanks a lot. Goodbye.